Let's look at patent infringement under 35 U.S.C. and particularly 271A. So this is what the statute looks like for basic patent infringement. So what are we talking about? I've highlighted some key words that we're going to talk about, starting with what is the patented invention? You may be wondering, does a patent invention mean all the claims in the patent? The short answer is no. Each claim stands on its own and is separately enforceable. So the patent invention, i.e. a claim, is enforceable against any defendant. Now the second question is, who could possibly infringe? It's anyone who is without authority doing one of these things that are in pink. Now, without authority basically means anyone who is not authorized, i.e. not the patent owner itself, and also not a licensee. You may also be wondering if you might innocently infringe. You might, but you are still liable. Patent infringement is a strict liability offense. Knowledge of the patent is not required for liability. There's nothing here that says that you have to know about the patent, and so you should know ahead of time that this is possible and try to avoid patent infringement, obviously. Now, what would be infringing? Well, I've tried to color code all the things in pink: making, using, offering to sell, or selling the invention, as well as importing into the United States. So over here, we've got an image of the United States to emphasize or reinforce that all these things have to be within the US. Otherwise, there is no jurisdiction. Now, what could infringe? We already talked about these activities. Could a patent, the existence of a patent itself, infringe? The short answer is no. Why not? Well, a patent is not itself making or using or offering to sell. When we talk about one of these things existing, we're talking about a product or a process that has all the elements of the patented invention. So if the patented invention is a car, then only an actual creation of the car or an offer to sell the car would infringe, not someone else's patent on a car. You may also be wondering if having your own patent is a defense to infringement. Now, obviously, this provision is just about liability, but there is no provision under the patent laws, whether statutory or common law, that provides a complete defense to patent infringement by having your own patent. In fact, it is entirely possible for a valid patent to be granted on something that is an improvement on an existing patent and yet would still infringe. That may sound strange to you, but don't forget that patents are supposed to promote innovation. The patent system doesn't say that, well, we only want to promote innovations that never infringe. Now, it's true that it might be difficult to use your patented invention without infringing someone else's, but what you could always do is seek a license and or maybe cross-license so that both the original patent owner and the patent owner of the improvement could maybe use the same patents or have some mutually agreeable relationship. So we already talked about where it has to be solely within the US or imported into the US. So if you entirely made a patented product outside the US, there is no US patent infringement. Depending on where you're doing it, you could be violating the patent of another country, but not the US patent laws. And lastly, although we've been focusing on direct infringement, someone who is actually doing all the elements of the patented claims, technically there are other provisions. You could have liability for someone who is helping with the direct infringer. So actively inducing would also create liability. So it only creates liability if someone is still directly infringing, but just as you could have a murderer and somebody who is an accomplice to the murder, so too patent infringement can create liability for people who assist in violation of a patent. So hopefully that's a helpful overview of the big picture of 271A.